Anyhow, I told my wife that this was on TV.
She knew.
So she said she watched the first 2 minutes.
I should say smooth stream now. So you can say whatever you like to your wife.
She's not watching. She said,
wait.
Go up, rise.
I see we have the guidance.
we do.
Thank you very much. Whoever's industry was responsible for producing it over lunch. Very grateful.
Yes. My learned junior was almost entirely responsible for the industry. And,
Well, thank you to Mr. Riley Smith for that.
if I may, can I take you back to the original order, which is at page 9 and following of the supplemental bundle. And before lunch, I was going to show the differences between the audit and the auditor's review. And I appreciate the fact that you have read this document at least once, and parts of it at least twice in the course of this morning, but I hope not to be too much longer in making some points, but there are points which we believe are important. First of all, The background is that in June 2017, GMCA decided to prepare an assessment of a scheme in accordance with the Act. TFGM were instructed to prepare the same in accordance with the Act and the franchising scheme guidance, the guide. In June 2019, TFGM's assessment was completed. GMCA also decided to proceed to the next step by instructing TFGM to obtain a report from an independent audit organisation. Following that, Grant Thornton was instructed to prepare the report. The responsibilities of TFGM, that is, the client too, were to prepare the assessment, to provide them with any such info as might be reasonably requested, to respond to queries that may be raised, ensure there are appropriate resources, and any such other matters as may be agreed and set out in the implementation plan. There's a management letter of representation confirming they have provided us with the information they believe we require in relation to the Act. And our responsibility is to provide a report and express an opinion in relation to the following areas required by the Act. Whether the information relied on by TFGM, in considering the matters referred to in section B, 3D, affordability, or 3E, value for money, is of sufficient quality, whether the analysis is of sufficient quality, and whether TFGM had due regard to the guidance in preparing the assessment. As per 8.1.87 of the guidance, our rule is not to report or pass judgment on the decisions taken or the outcome of the assessment. Our role is purely to consider the process that's been followed, the accuracy and robustness of the information that's been used, and that the mechanics of the process have been carried out correctly. Now, we now all have, thanks to Mr. Riley Smith, the guidance. And page 20 does indeed sets out 1.87, pretty much as it's been précis. You may wonder why the guidance has a large amount of it underlined, almost like an amended pleading. That is because the statutory guidance is underlined and non-statutory guidance is not. And as Mr. Howe kindly reminded me before, it's at the top of page 5 that it explains that statutory guidance is underlined. So you know, what we're looking at 187 is statutory guidance. I won't read it because I've already summarised it. The next part of Grant Thornton's audit refers to paragraph 1.85. And we say this is an important paragraph. It again is statutory guidance, and it requires them to take into account the quality and timeliness of information received from bus operators and the following criteria: whether the information used comes from recognised sources, whether the information used is comprehensive or selectively supports arguments in favour of or against any option, whether the information used is relevant and up to date, whether the assumptions recorded are supported by recognised sources, and the mathematical and modelling accuracy of analytical methods used to calculate the impact of the options. Now, what paragraph 1.85 is said to say in the audit is paragraph 185 requires us to take into account the quality and timeliness of information received from bus operators. And that is indeed what is said. But that's when forming their opinion as to the information relied on. Now, obviously, the information received from the current bus operators is going to be key to looking at the models and deciding whether what the current use of buses is, pricing, and all the like of it. So it's obviously that is key information, and it's 1.85 again is faithfully set out by Grant Thornton. And again, for your note, it's page 20 of the guidance, and it's all underlined. But one point that I made this morning, I'll make again, is that the guidance, when it applies, does identify how you can, but the criteria to be applied to deciding whether the quality and timeliness of the information, one of which is whether it's relevant and up to date. Now, you only get those criteria, of course, if you use the guidelines. And as we know why, but as we know, Grant Thornton did not use the guidelines in their later assurance or auditor's review. And as I say, we know why they didn't, but the fact is that they didn't. And therefore, the ability for the auditor to decide if information was of sufficient quality, and my Lord Justice Snowden before at the lunch adjournment pointed out the wording about sufficient quality in the later. But the fact is that the criteria for determining sufficient quality are missing from Grant Thornton's second review because, of course, they didn't apply the guidelines because they couldn't, because they weren't carrying out a statutory audit.
You say the criteria for assessing sufficient quality are the criteria in 1.85?
Yes.
But that only applies to information coming from bus operators.
Yes.
What about other information? Because 1.84 deals with other information.
Yeah.
And that's got to be of sufficient quality.
Yeah.
So do you apply 1.85 to 1.84 information by implication, or how do you assess sufficient quality?
Well, we would say although it does refer 1.85 to received from bus operators, it then also says, and the following criteria, which must refer to all the information relied upon. There's no reason to make the information from bus operators subject to a sufficiency criterion, none of the other information. I mean, this is, of course, it's guidance, it's not.
Yes.
But
it doesn't tell you how you assess the quality and timeliness of the information from the bus operators either. But
well, apart from seeing if it's, for example, up to date.
Yeah.
And we know that the assessment used information from 2016 and 2017. And then we conducted our work in accordance with international standard, IS EA 3000 revised, assurance engagement other than audits, and applying that requires us to conclude whether the assessment has been prepared in all material respects in accordance with the requirements of 123D of the Act. So we say that is a comprehensive audit. The avoidance of doubt.
But it's only comprehensive, you say, because you have to follow the guidance which tells you precisely how you go about the task.
Yeah, and it's comprehensive because it says it's in accordance with the requirements of Section 1.
But simply because you're not required to follow the guidance, how do you get from that Grant Thornton haven't taken into account in assessing whether the information is robust enough, that it's come from recognised sources or is relevant or up to date?
I was hoping to run through this and then run through the second document. If your ladyship would prefer me to go straight to the
No, you take your own course.
The point I was trying to make was that they then talked about the standards of quality control and they comply with the independence and ethical requirements. And then page 11 is our approach to meeting the requirements of that was as follows, and I've taken you to that before, so I won't take you to it again. But the process is in accordance with the guidance. There's an assessment review. There's a use of base data, including operator data, and that says this element of work evaluated the quality and timeliness of the information used to underpin the assessment of whether the analysis was of sufficient quality and whether TFGM had. So that seems to suggest it's all the base data that they used the guidance towards, which is, I think, my lady's point. And in relation to the models, they've undertaken calculation reviews, analytical reviews. Then the big paragraph at the end of this page, before inherent limitations, section 123B, 3D and E requires the assessment to include consideration of whether the proposed scheme is affordable, represents value for money. In reviewing the assessment, we set a threshold for materiality at a level where a finding is considered material if it demonstrates the scheme would no longer be affordable or represent value for money and would not be consistent with section 23B, 123B, 3D and E of the Act. During our work, we identified and collated a number of observations which we've reported. None of these issues considered sufficiently material for us to issue a modified conclusion. And then inherent limitations. We've not done an examination. Our report relates only to the assessment. It doesn't extend to any financial statements or statutory financial statements of the bus operators. We've not considered the whole internal control system or tested it. The modelling necessarily involves simplified representation of the real world using a set of data and input assumptions and calculations to provide forecasts that inform decision making. As a result, there's inherent uncertainty over forecasts and projections calculated by our modellers. These are based on a series of assumptions from which future actual outcomes may differ. A report has been prepared by Grant Thornton.
And that would be true of the projected assumptions that will be used on the next report as well?
That may well be true, yes. Yeah. Albeit that those projected assumptions were not tested by reference to the Act that these were. And that's our point. For the avoidance of doubt, and then, in our opinion, in all material respects, the information relied on in considering the matters referred to is of sufficient quality. The analysis of the information is of sufficient quality, and TFGM had due regard to the guidance issued in preparing the assessment. So there we are, a clean bill of health in September 19. Now, we then turn to 142, which is the 19th of November 2020. This assessment, reviewing, it's page 142, I'm so sorry.
Is it the same bundle or a different
It's
bundle?
the same bundle. It's supplemental bundle, page 142. I'm sorry, it's awkward the way these documents are put together. I do apologise.
Yes.
This assessment is made in accordance with our call-off contract. Its purpose is to provide GMCA with independent assurance on the approach taken by TFGM in preparing the COVID-19 impact on bus franchising report. In background, in 2019, Grant Thornton provided its opinion on TFGM's assessment in accordance with section 123D. From October 19 to January, GMC consulted, and in June, TFGM reported. As the potential implications of COVID were not taken into account in either the assessment or the consultation, GMCA noted the contents of the report, requested TFGM to prepare a further report to consider the potential impact and the effects of COVID on the bus market. The report should be read in conjunction with our opinion of the assessment dated 26 September 2019. For the avoidance of doubt, this report hasn't been prepared in accordance with section 123 of the Act. Then, responsibilities of TFGM, they are to prepare the report, provide us with information reasonably requested, and respond to queries. Our responsibilities are obviously significantly less constrained and obviously do not refer at all to that Act, other than to say that we can't report on where there's been a departure from the guidance. Although they do say we also report on those instances where TFGM has departed from the guidance, comment on whether such departures are appropriate or not given the circumstances. But as you know, they actually then say, well, there is no guidance, so there's nothing to report on. But in particular, look at whether the approach taken in the COVID impact report in considering the affordability and value for money is appropriate, as opposed to whether it was of sufficient quality.
Well, no doubt it would be inappropriate if it wasn't.
Well, lady, with respect, it doesn't say that we have looked at whether it is of sufficient quality at all. It says,
No, it doesn't say that, but if it wasn't of sufficient quality, how could it be appropriate?
Well, my lady, we rather take the view that this wording is deliberately used, and deliberately used in a non-statutory sense, to take it out of the remit.
Well, we all know it's not a statutory review. We all know it's not a section 123D. That's your
Yes.
whole complaint.
Yes. So,
But I come back to a fairly simple question. If it's not of appropriate quality, if it's not of satisfactory quality, how can it possibly be certified to be appropriate?
well, what is being asked is whether the approach taken is appropriate. Those are words which are not, in any way, we say, the same test as the audit test. They are not at all the same as saying whether what has been done is of sufficient quality. Just saying whether an approach taken is appropriate. Now, this is what the auditor is being, the independent auditor is being re-instructed to look at. And it is, in our respectful submission, beyond peradventure that it is it's a different exercise entirely from the first one. The second
Well, can I just interrupt? I'm sorry. I don't want to prolong things. The COVID created a completely uncertain landscape.
Yes.
And the COVID impact report sought to address that with these 4 scenarios as best it could.
Yes.
And what in this first bullet point, the auditor, assessor, whatever we call it, is doing is saying, well, that's how the COVID impact report approached this wholly unforeseen and wholly extraordinary set of circumstances. Was that an appropriate way of going about it? That's all it's doing.
Yes, my lord, whatever appropriate it means, but what it doesn't mean, we say, is it doesn't mean sufficient quality, because it doesn't say sufficient quality. Now, it's
No,
right
that's
to say
in the next bullet
that
point.
the next bullet point refers to sufficient quality, but the next bullet point, which refers to sufficient quality, does so without reference to the guidance at 1.85, and the guidance tells us what is to be taken, what criteria to be taken into account.
So simply because it doesn't mention the criteria, one assumes that it doesn't apply the same criteria in deciding whether the quality is sufficient. Is that the point?
It's not that one assumes that. One takes it as read that they haven't supplied.
Right, so they've applied some different standard to the sufficiency of the... You say that one can take it from the fact that it doesn't mention 1.85, that Grant Thornton have taken it upon themselves to apply some lower standard for sufficiency of quality.
Well, yes, not least because...
You're seriously advancing that proposition.
I am seriously advancing the proposition, my lady, that they deliberately did not follow the guidance. Because
Yes, that's a different point with respect. Are you seriously advancing the submission to this court that Grant Thornton decided deliberately to apply a lower standard when assessing sufficiency of quality to that which they were mandated to apply when using a statutory guidance?
Well, could I take you please to page 1446, which says departures from the guidance,
Yes.
which says our scope of work required us to report on instances where, in preparing the report, TFGM has departed from the guidance issued under section 123B of the Act on preparing the assessment. We note that the guidance didn't consider the impact of a global pandemic and any input updates that would be required to the assessment as a result. As there is no guidance that TFGM could follow, we have not been able to report in this regard. So I say that what that means is that Grant Thornton, there is no evidence before this court that Grant Thornton did apply the criteria in the guidance.
And there is equally no evidence before this court that they didn't.
But there is evidence that they took on board that the guidelines didn't apply to this situation because they hadn't been foreseen.
Well, surely all this is saying is we've been through this document with a fine-tooth comb, and nowhere is there a heading saying global pandemic.
Yes, my lord. And the other thing is...
That's what this is saying,
yes,
surely.
but they've also not, in terms, they have not listed what they did list in their first report, which was their audit, which was a list of the criteria they needed to apply to decide.
Sorry, I'm not sure this paragraph says what you just said it says.
Oh.
It says, our scope of work required us to report on instances where in preparing the COVID impact report, TFGM has departed from the guidance issued under the Act.
Yeah.
Because the guidance, as we've now seen, it only has a little section actually from between 183 and 187 dealing with what the auditor has to take into account when forming an opinion. The rest of it is all to do with guidance for the authority.
Yes, my lord, that's quite right.
And so what they are saying here is we can't report on whether TFGM has departed from the guidance because there is no guidance that TFGM has followed. That says nothing about whether the auditors, Grant Thornton, have continued to follow the guidance.
But my point is this is obviously a carefully drafted document, and in the first carefully drafted document, which was the audit, they did refer to the guidance. And in this carefully drafted document, they don't refer to guidance at all. Now, it's right that they didn't refer to 1.84 in the first document either, I accept that. But what I say is that there's nothing to show that in coming to this independent assurance review, Grant Thornton did apply the statutory guidance, and because
it's more than the statutory guidance. I mean, they don't have to apply the statutory guidance because they're not exercising a statutory function.
No.
But the point that I am grappling with is how one gets from that to say that when they're assessing the quality of the work that's carried out, they're applying some lower standard.
Well, could I?
Because common sense would tell you that if you're trying to assess the quality of what's carried on, you'd apply the same criteria throughout, otherwise you get an inconsistency.
Well, that might be right, in which case, but it's not being said, is it, that this is in any way an audit? The opposite is being said. Yeah. It's not being said that this is in any way a statutory, some part of the statutory requirements of the Act. So whilst it may be, in common sense, believed that it is likely that Grant Thornton did apply the same criteria as they had applied to whether matters were of sufficient quality or not, the report does not say that.
It doesn't say so in terms. Let's just test it though. If you've got 1.85 of the guidance up,
Yes.
this was what you drew our attention to.
Yes.
This is when forming their opinion on whether the information relied upon, etc., is of sufficient quality in relation to information received from the bus operators. You drew our attention to whether one of the criteria they had to, the auditors had to use, is whether the information used is relevant and up to date. Yeah?
Yeah.
So if you go to the middle of 145
Yes.
of this, the supplemental bundle,
Yes.
for example, under the heading Value for Money Approach and Analysis,
Yeah.
if you look at the beginning of the fourth paragraph,
When taking account.
when taking account of the age and relevance of the evidence used to support the value of the branding benefits in the original assessment, etc. I mean that's a reference back to what they were doing under the original audit of the assessment, yes?
It seems to be.
And why do you then say that they didn't have regard to that or take account of that particular piece of guidance when they're producing this document? I mean, they expressly refer to the fact that they had used it in the original assessment, brackets, which remains the case. I mean, I'm struggling to understand why you can say we must assume that they aren't, in effect, using the same criteria. Why do you assume they close their eyes to the criteria when they're expressly referring to them there?
My lord, if you go back to page 10, I'm sorry to drag you to right. If you see in page 10, our responsibility.
What, where they set out
Yeah.
the statutory guidance,
Yeah.
in effect.
and the auditors should take into, and then they talk about 185 and requires us to take into account the quality and timeliness of information, etc.
Yeah.
They say that, but in 1.4, and they have a section of our responsibilities, and they say the 3 bullet points what their responsibilities are, and then there's a whole slew of information about the guidance. But if you look at 1.4.3 in our responsibilities, there are 3 of them, and then there's some more information, but nowhere does it say that we are required to take account of the following guidance.
I mean, I suspect you haven't, you may have made this point, and if so, I'm sorry I missed it, but maybe your point is that just above the word findings,
yes,
you say for the avoidance of doubt, our report is not, and then there's a little dash, based on any other formal guidance. You see that just about level with the second hole punch. Page 143.
yes.
Sorry, you haven't got a
Yes,
hole punch
exactly.
on the computer.
Based on any, no, I don't. I'm afraid my electronic device doesn't have a hole.
Doesn't have a hole punch, but
No, exactly.
so you say that they've actually said that they haven't based their report on any other formal guidance.
And if they wanted, it would have been perfectly straightforward for them to say, notwithstanding that this isn't an audit under the Act, and notwithstanding that we're not obliged to follow the guidance because it's not an audit under the Act. Nevertheless, we obviously have, because this is to be read in conjunction with our previous audit, we've obviously carried on with the guidance. But the fact, my Lord kindly points out, they first of all don't say that, and secondly appear to say the opposite. And then, my Lord, we've got the findings. And the first general finding at the end of this is, in the middle of this, they say, whilst we accept this is a reasonable argument to make, that's an argument about it being a central pillar of this transport strategy. This is 143, sorry.
Yeah.
We highlight here, and specifically in sections below, that COVID-19 pandemic has created significant uncertainty and therefore has not allowed for as accurate forecasting as was previously the case. GFGM accepts this principle and accepts it and chooses to proceed now. The risk has increased that the outturn material position may be materially different from the central case previously set out in the assessment. So, the reviewer who originally provided an audit that said the information is sufficient quality and etc., we've checked all the models, now says TFGM accept, bracket, because we've told them, or because they've said it themselves, that the outturn position may be materially different.
Yeah, because the COVID pandemic created significant uncertainty. Nobody knows whether people are going to go back on buses.
So our point is, so this, starting from that part alone, how can you, as a rational decision maker, still be satisfied that the value for money and affordability criteria of the Act still apply?
If you take that submission to its logical extremes, it means that because there's a pandemic, you can never have a viable franchise model.
Or it means you wait till it's over. You say, as so many people did.
But I thought your case was that they should have carried out an audit, not that they should wait till it was over.
Or carry out an audit.
Well,
Both of those points are
Well,
no, we say you should have carried out an audit, and they didn't. But it was their choice to move forward at all in the middle of the pandemic, and to move forward without carrying out a further audit.
but it's not a statutory audit. We established that. Sorry, we didn't establish that. That was the argument we had this morning. That's the premise. So the premise of the argument we're now having is that it wasn't required to be a statutory audit.
If it's not unlawful to instruct this piece of work,
So
if it's not.
even if you had a quote statutory or applied the statutory audit criteria to this report,
Yeah.
when doing this report, would it have said anything different than this? Wouldn't it have just said exactly this, that it's going to be very uncertain, there's an increased risk that the outturn position may be materially different? What difference would applying the audit criteria have made?
if we look at the analysis that follows on from the general analysis, so-called analysis, if we take, for example, funding and affordability approach and analysis, which starts at the bottom of 143. Our original report noted that the assessment didn't include an annual assessment of the budget. Instead, it was provided in a separate report. The COVID impact report confirms that each component of the original funding agreement has been reviewed and these sources remain available. COVID impact report notes there are additional financial pressures across GMCA as a result of COVID. We understand the previously approved funding arrangements are to be considered in the CA report. The COVID impact report also indicates that the assumptions around the approved value of the precept are less prudent than in the assessment due to future uncertainty around Greater Manchester tax base. However, the analysis that's been undertaken indicates the assumed value has been calculated on a reasonable basis in the context of the information available. The CA report includes the COVID impact report and the proposed funding strategy. We note no updated annual profile of the budget has been provided, but the impact on the profile previously agreed has been described. The assessment previously noted that further funding will be desirable. The impact report goes further and indicates that this may be necessary, particularly if material downside risks, for example, the risks inherent within scenario 3, were to materialise. COVID impact report recognises present uncertainty that exists in the market, sets out the central case is now subject to significant uncertainty. Financial case concludes material risk is to fare box revenue assumptions made, and notes that, based on a range of scenarios, unmitigated change to the assessment assumptions for the transition period could be between a 31 million nominal increase to a 292 million nominal downside in revenue. Whilst the potential range across the 4 scenarios is significant, TFGM considers scenarios 1 and 4 are more likely to reflect the potential bus patronage recovery, which shows a narrower range of downsides, and 2 and 3 are viewed to be less likely upside and downside. The COVID impact report provides a high-level assessment of a range of possible short, medium and long-term mitigating actions, considers the risks and issues associated.
Singer, I'm a bit conscious of the time. I don't want to stop you in full flow, but reading out large chunks of the report is not terribly helpful.
Well, what I was trying to submit by reading it out, I'm sorry, my lady, for taking up too much time, is that if I can just take you just to 2 paragraphs at the end. We agree, at the end of page 144, as noted in the impact report for all scenarios, financial support to the bus industry will be required to enable recovery, though there's currently material uncertainty as to the form, value and duration of this. In summary, the approach taken to considering the affordability appears to be appropriate in the context of the limited amount of information available on which to prepare detailed analysis. Based on the information provided in the COVID impact and supporting, the analysis appears to be of sufficient quality. Now, we say that's nowhere near the test that you would have had to apply if you were an auditor, because they have limited information on which to prepare detailed analysis. There's modest information provided, but on that basis they say the analysis appears to be of sufficient quality. Well, by reference to what?
Well, sorry.
I mean, all the same.
The analysis is what they've just been detailing for the page
Yeah.
that you were reading to us. That's the analysis,
Yeah.
based on limited information.
Yeah.
Now, the question is whether
But
the information is of sufficient quality.
they don't say it is. They say based on the information, the analysis.
No, they say the analysis is of sufficient quality. They don't say that the information is of sufficient
Exactly.
quality. Where do they say? I mean,
No, that's right.
Well, they specifically say, by definition, we've got limited amount of information.
Yes, exactly.
I mean, it seems to me, correct me if I'm wrong, your complaint is, and you almost said this a few minutes ago, given that the pandemic created such uncertainty, the authority shouldn't have made this decision at all.
Why?
The decision in March.
Yes.
Yeah.
That's the irrationality.
And
The Grant Thornton did their best,
Well,
given that
well,
you simply have so many uncertainties.
but the specific point about Grant Thornton is that they were used as an independent assurance review, and and if that had been a properly evidence-based analysis, as the audit was, then that would have been one thing. But our point is it's the opposite of that. And it makes statements about things, limited things being appropriate in terms of analysis, but not in terms of information. It doesn't provide any objective basis on which a reasonable decision maker can say, I'm going to rely on this.
Right, well, I understand that point,
Yes.
and it's simply put. Yeah.
Great. And I'm going to go on to say that you can see the same point in the value for money part of the
third paragraph.
Yeah.
Page 145.
Yeah. And quality of information available is significantly less.
I'm basically saying the analysis is okay, generally unreasonable, given the limited information that is inevitably available after the pandemic.
And then clearly they have their inherent limitations. They haven't undertaken any review of the financial models.
But if you have that limited available information, you wouldn't be able to carry out a proper audit anyway.
Well,
so why should they have to go through an unnecessary? I mean, I take the point that the overarching point that in the light of the pandemic you can't carry out any meaningful assessment whatsoever of the uncertainties, and therefore you hold your fire and don't make a decision.
Yeah.
Not quite the case that was the subject of permission to appeal, but
well,
leave that to one side. Your case, as I understood it, was you have to carry out the statutory audit, notwithstanding that there is no statutory requirement for you to do so. And not to do that is irrational. And I'm pointing out that on the case that is now being formulated, you couldn't carry out a statutory audit because you'd be in even more difficulty carrying out a statutory audit than Grant Thornton were in the more limited.
All right, I think what you just right. Sorry, cut across my lady. What you might be saying is, actually, you could do a statutory audit, but they'd never be able to give the certificate required by the first subsection, namely that the information was of sufficient quality. Sufficient for what is the question? But you would say the information is, at the moment, is not of sufficient quality to give an audit certificate.
And if you had done the audit,
right,
you would have said, hold fire because we haven't.
But strange enough, that's what they actually are saying here, is it not? In truth, they are saying the information is really not the sort of information that you would get during times of relative stability. So they convey the same message by something which...
Well, except the message may get lost in translation because it may not have been subject to quite the forensic analysis that it has been in this court today. And
well, I'm sure that a lot of people were looking pretty closely at these documents.
Well, yes, but when the GMCA look at the auditor's review, they clearly rely upon it. And not for saying there isn't enough information to do a proper audit at this stage. That's not what they say at all. Because
Well, I mean, let's not.
we can see what they say.
The auditors say this isn't an audit. This is us doing what we've been asked to do, and here's what we've been asked to do. And by the way, there are a lot of uncertainties here, so be warned. I mean, that's not what it says in literal terms, but the reasonably educated, informed reader would not have much difficulty getting that's the message.
Yeah.
And then the authority take a decision. They obviously decide, well, we know how things were assessed to be in normal times. We've got the COVID report. Well, we're going to carry on, notwithstanding all the uncertainties of the pandemic.
Well,
and as I understand it, you're saying that was irrational.
we're saying it was irrational to rely on an assurance review in lieu of an audit, and that's what paragraph 58 of our skeleton says. And we go on to say that there was a false sense of security that would have been derived from the fact that GT had further considered the COVID impact report, and it was relied upon, as we can see, because in the March report, which I'm not sure I've yet taken.
Right.
Well,
Sorry.
Your Lordships too. No, that wasn't it. I do apologise. There's no meant to be criticism at all. It's a criticism of me. But if we take take you to that now. I was just addressing the point that it was being suggested that my case wasn't quite what it now is. If you look in the March report at page 427 of the core bundle, this was the report that was read before the decision was taken. The decisions were taken. At paragraph 13, we see it at 13.4. Having considered points raised, it's not agreed that the respondees have shown either that GT failed to consider anything material or that its opinion was not one they were reasonably entitled to reach when carrying out their audit of the assessment. Further, with regard to the criticisms, GT's approach to its review of the COVID impact report made during the second consultation period, it's not accepted that a further audit report was required under section 123D of the Act, but rather that reliance can be placed on GT's conclusion in respect, and that's obviously a typo, of it. So, it is clear that in reaching their decision, the respondents relied on the assurance review, expressly accepting, because they decided they didn't need one, that it was not an audit. And we say that was an irrational decision to take, especially in the middle of a COVID pandemic. And rhetorically we say, if you do not need to have a re-audit of your assumption, your assessment, in the middle of a pandemic, when do you need to have one?
Wait a minute. There's an element of bootstraps here.
Yep.
The premise for this argument on irrationality is there was no statutory requirement to go back and get an actual audit under 123D.
Right.
So there was no requirement to get the certification as to the sufficiency of information and analysis.
Right.
So you don't need to do that.
As a matter of statutory interpretation, you don't need to do that.
Right, but what you're saying is it was irrational not in fact to have required the auditors to follow exactly those statutory tests
In these circumstances.
in this report.
Yeah. Sorry, my lord. Excuse me. And in these circumstances, which were unprecedented.
Right. And you say the effect would have been, if they had have done, the auditors would have said, actually, we can't give you the sort of informal certification about adequacy of information.
Or of
Right.
quality, and therefore,
But the authority would still have been able to say, well, thanks very much, but it's not a statutory audit. So we can still make a decision based upon what you've told us is that the information isn't as good as it would be required to be if it had been a statutory audit, which it is not.
well,
They can still make a decision, can't they?
well, maybe, but I don't think that their case is that it doesn't matter either way because we could have done it anyhow. I think their case is that it was a perfectly rational thing to rely upon, and indeed we know they relied upon it. So the point is of what might have happened had they had something different. And then had they said in 13.4, instead of saying what they said, saying actually we instructed GT to give us an equivalent of a statutory audit, they said they couldn't do it because they didn't have the information, but were going ahead anyway for the following 5 reasons. That might have been a different argument in this court, and in fact in the court below, but that's not actually what happened. That's not actually the basis on which they decided to make this decision. The basis on which they decided to make this decision was because they could rely on this assurance review. Yes, and of course if they had ignored what Grant Thornton said, that might have given rise to a different irrationality challenge. Well, I'm conscious of the time. Unless there's anything further I can assist. Thank you.
Mr. Howe.
My lady, my lords, I'll first deal with the statutory obligation point first and the rationality point second. we should start by making 4 general points about Section 123D and its place in the statutory scheme. The first is the Act identifies unambiguously what an audit under Section 123D is an audit of. If your Lordships could have the authorities bundle. I don't know if you have tabs as well. It's at page 8 in tab 1. And the court will see in subsection 1 that if after preparing an assessment of the proposed franchising scheme under section 123B, the authorities wish to proceed with the scheme, they must obtain a report from the auditor on that assessment. That is the one under 123B. And that's reflected also in what the report has to contain in subsection 2. It refers back to 3D and E, which is, of course, affordability and value for money. The analysis of that information in the assessment is of sufficient quality, and also that you have regard to the guidance in preparing the assessment. So, in my respectful submission, the first point which is clear is that the subject matter of a report under 123D is the assessment, any assessment under 123B. Secondly, the Act makes plain in 2 sections when an audit under that section is to be obtained and its function. First, as subsection 1 of section 123D makes plain, is to be obtained after preparing the assessment. And then secondly, if your Lordships go on to page 10, section 123E, subsection 1 provides, if after obtaining the auditor's report under section 123D, the authorities wish to proceed with the proposed franchising scheme, this section applies and you go to consultation. So it's a report which is to be obtained after preparing the assessment and before consultation. And its function, as one will see from subsection 2, is that it's one of the documents which is published together with the assessment for the benefit of those who are being consulted about it. So it helps those who are being consulted about it. Thirdly, the Act does not itself provide that any further analysis of the likely effects of the scheme or of any alternative to it must be the subject of any independent audit before that analysis can be relied on. And I want to look in detail a little later about what sort of analysis you're going to get, but you can get it in consultation response, the authority's response to the consultation, various other matters. But there's nothing in the Act which says anything about a further audit. Fourthly, although the Act itself contains no provision about auditing further material, it is a matter on which the Secretary of State could, had he so wished, make provision by regulations or in guidance under the Act, but he has not done so. Firstly, in terms of regulations, if your Lordships would go on to page 38. Section 123U, unfortunately this scheme adopts the new habit of the legislative draftsman of having letters in the sections. Your Lordships, under subsection 1, the Secretary of State may by regulations make further provisions with respect to the procedure to be followed when making the scheme. So if the Secretary of State wanted to insert a procedure for audit of something further than the 123B assessment, he could so provide. And similarly, if one goes a few pages further on to page 42, he could also provide further guidance under the Act about it, in section 123W. The Secretary of State may issue guidance concerning the exercise by franchising authorities their functions under this part in relation to the franchising scheme. So, again, if the Secretary of State wanted to, could have provided guidance about when, if at all, you should have a further independent audit. But he's not chosen to do that. Now, with the appellant's actual case as in the skeleton argument was that there was a statutory obligation to obtain a report on the COVID impact report. Now, in my submission, there could be no statutory obligation to obtain a report under section 123D on anything other than an assessment provided under Section 123B.
I think that was why Mr. Singer was driven at one point to say that it was an extension of the 123B
I want to come to that in a moment, but can I just finish this point? The judge found that the circumstances were not such as to require the authority to start the statutory procedure again by making a 123B report assessment. Can I just give you the references for where that's in the judgment? The contention is set out in paragraph 173, which is page 127. And the judge addressed and rejected it at paragraphs 178 to 183, which is at pages 129 and 131. That's not merely a finding which is not impugned on this appeal. Permission to appeal on that matter was refused. It was part of ground 2, which the Learned Law Justice refused permission on. You'll find that at paragraph 6 in the core bundle at page 53. And the assessment, the COVID impact report was not a new assessment prepared under Section 123B. It didn't purport to be, and it wasn't. And so my respectful submission is the judge was entirely correct in what he said at paragraph 197.
I mean, you say that's the beginning and the end of the statutory.
Yeah. My submission it is. But as I understand, my learned friend had two main responses to that. Yeah. The first was that the COVID impact report was or should be regarded as an extension of the assessment and in some way to be treated as if it's part of an assessment and therefore generating a 123D obligation. And secondly, that there was an implied statutory obligation to obtain a further report under Section 123D, and that should be implied, I think, if there's some material change of circumstance. I hope I don't do him injustice, but I think those are the two main points he was making. The first point, that it should be treated as part of the assessment, or is an assessment, doesn't sit well, if I may say so, with the argument that we should have started again and should have prepared an assessment if in fact we did, but that's, my friend can do that. But what he has to explain is what will count as something which is to be treated as part of an assessment and what is not. Now, for this purpose, can I illustrate what will in practice happen under the Act? Just to
but by definition, you say it's something that couldn't take place after consultation.
Yeah. Can I explain to you what actually happened in before one even gets to the COVID, so you understand it? Your Lordship will recall what an assessment under Section 123B has to do is to have a look at the likely effects of the alternatives as well under subsection 2. If you go back to what it actually has to do, apart from giving consideration, this is at page 5 of the authorities manual. The assessment has to describe the effects that the proposed scheme is likely to produce and compare the proposed scheme to one or more courses of action. And of course, one of the reasons for doing that, if you're concerned with value for money, is some alternative may give you better value for money. So that's an important part of it. And so when an authority has to would look at responses to consultation, there were a whole series of alternatives which were put forward during the consultation in this case. And to give your Lordships an example of that, if you could take the supplementary bundle and go to tab 7 at page 91. This is just the index to what was the report on consultation in March 2021.
Sorry, give me the reference again.
This is just the index. This is tab 7, page 91 of the supplementary bundle model. Can I just explain what had happened in the assessment first, and then one was see how this worked. In the assessment, you had to consider a do minimum position, which is nothing happens. There was a proposal for a voluntary partnership, which operators then offered. And the authority also considered what might be achieved under what was called an enhanced partnership. What then happened was, during the first consultation and the second consultation, various other alternatives were put forward. So sections 10 going over to, and includes up to 14, were all different alternatives which were being put forward for consideration. So in terms of this document, that required analysis from page 440, going over the page, to page 551. So there was all that further analysis of alternatives which were being considered. Two of them came up in the second consultation, the others were in the first consultation, but one can see the nature of the exercise which is going on. And so that's further analysis there. When the authority comes to make the decision, it obviously also has to consider the information which is available as at the date it has to make the decision in the public interest. And one of the things which happened in this case was that after these reports were produced, the Secretary of State produced a new national bus policy, including proposals for new finance of buses going forward. And that gave far greater incentives for bus operators to enter into what was called an enhanced partnership, something they'd hitherto refused to do. So one of the things which the authority had to consider, and they had a report before them, the mayor had a report before them, was to consider the implications of that and whether that produced a greater incentive and what would be produced by that greater incentive by way of an enhanced partnership. So it wasn't merely the consultation responses which had to address that, but also it had to address information which can come out independently of the consultation responses. Now, so it's not entirely a rhetorical question. Are all those matters additions to the assessment? They all go to whether the assessment's still good, whether you want to change something. Do you have to get an audit for all of those? And
well, I think your point is put it slightly differently. The sequence is clear.
Yeah.
Assessment, audit, consultation.
Yeah.
After consultation, the inevitable result of consultation, you say, is that a whole host of other people pop up and say, you could do it another way. We could do better. Secretary of State weighs in with a new changed guidelines. But none of that requires a new audit
or assessment.
Yeah. And if that foreseeable sequence of events doesn't require a new audit under statute, as a matter of statutory interpretation, why should anything else that's unforeseen? I mean, this is the point we laboured this morning. That's the point, isn't it?
Indeed. And can I do a little thought experiment? Assume for a moment the outbreak of COVID in the first lockdown had occurred during the consultation period, a consultation period. And the response to the consultation period said, you can't rely on your assessment because of the outbreak of COVID. And the response which the authority was to produce the COVID impact report as its response to that point. No doubt they would consult it again, but that would have just been the response to the consultation point. So, and on my learned friend's argument that the response doesn't need an audit, nor would the COVID impact report have required an audit at that particular point. In my respectful submission, the idea that in some way that it's an extension of the assessment and that generates a requirement to once again have a Section 123D report doesn't go there. Can I turn to the implied duty? Well, firstly, can I say something about the legal approach? The Act actually says what the requirements are. If your Lordship just goes back for a moment to Section 123A, this is, of course, subject to any regulations which the Secretary of State may make. But subsection 2 provides that you may not, a scheme may not be made unless the franchising authority complied with the requirements in Section 123B to G. So the Act actually says what are the requirements you have to comply with. And my learned friend is effectively saying that the Act ought to be interpreted or construed in some way as to impose a further requirement, that is to say, a further requirement for an audit, not under.
Well, he just implicitly slips a new subparagraph into Section 123D, so you don't need to change 123A too.
Very well.
I mean, he just wants to slip another subparagraph or two into.
What is the legal test for that?
Yeah.
Two authorities, one general and one actually applying it in the case of requirement. Firstly, for reading in new words into the Act, is the statutory test is in INCO. If I briefly show your Lordship that, it's in the authorities bundle, tab 3. I don't think the relevant facts matter, but it's Lord Nichols's description in his speech, which the other members of the committee agreed with. If you could go to page 89 of the bundle, and the relevant passage to read is from little c on page 89 to a on page 90, and could I invite the court to read that? Because my submission is that none of the criteria aren't met. Indeed, I don't think my own offence limits there.
I'm going to have to see if I can fit the word opuscule into my next judgment.
It's always a challenge.
Obviously not to Lord Nichols.
Yeah, I'm not entirely sure whether Lord Nichols and Lord Diplock ever had a competition about what you could insert. Anyway.
Yeah.
One illustration of that is the Salomon Sullivan case, very well known, but not perhaps for what it actually decided, why the House of Lords disagreed with the Court of Appeal in that case. Your Lordship will recall this is about whether you would have effectively a one-man company. If you go to tab 2, the reason I take it this, well, when people talk about implied obligation, what you imply into a statute, there are various different things you may be talking about. For example, ancillary powers, whether it's implicit in the language, and so forth. This is a case about whether you can imply a new requirement in addition to that which Parliament has specified. So that's why it's of relevance. And if your Lordship will go to, let's see, at page 26, just to see what the Court of Appeal said. This is internal page 26, page 50 of the bundle. And if I can pick it up in the penultimate paragraph, what both parties have appealed, this is just to see what the Court of Appeal actually decided. The Court of Appeal being of the opinion that the formation of the company and the issue of debentures pursuant to the agreement were a mere scheme to enable him to carry on business in the name of the company with limited liability, contrary to the true intent and meaning, and further to enable them to obtain preference. So they thought that this was something Parliament would never have intended, and that was why they thought that it shouldn't be done. If one goes then to page 53, firstly in the first speech of the then Lord Chancellor, Lord Horsbury, so this, my lords, the important question in this case, I'm not certain if it's the only question, is whether the respondent company was a company at all, whether in truth the artificial creation of the legislature would be invalidly constituted. And in order to determine that question, it's necessary to look at the statute, what the statute itself has determined in that respect. I have no right to add to the requirements of the statute, nor to take from the requirements thus enacted. The sole guide must be the statute. And then, if you go on to page 54, I will, for the sake of argument, assume the proposition that the Court of Appeal laid down, the formation of the company was a mere scheme to enable Aaron Salmon to carry on his business in the name of the company. I'm wholly unable to follow the proposition that this was contrary to the true intent and meaning of the Companies Act. I can only ascertain the true intent and meaning from the Act itself. And then at the bottom of the page, if you could just read the highlighted passage, is probably the quickest thing to ask you. can I emphasise, obviously making the point you need to know what you've got to read in, but I also emphasise the point that he makes. The question can't be answered by a reply that it's a matter of degree. If the legislature intended to prohibit something, you ought to know what that something is. So if one's looking at the type of implication which Malone Friend was put for, some material change of circumstance, that's a question of degree, effectively, or how else is it to be judged. And in my respect for Commission, that's not sufficiently precise to add to a statutory requirement which you must comply with before you can actually make a decision. Lord, the other passage at bottom page 57 to 58. Well, I'll pick it up with my Lord, the truth is, and if your Lordship could just read that. My lords, that effectively the inexpediency is precisely what my learned friend is arguing about. He said that it'd be very unfortunate if you go ahead and do all of this. Lord, the other passages which we marked out is Lord Watson at page 61 to 62. And if I just pick it up in 62 very shortly, where he sets out the proposition about halfway down. It says intention of the intention of the legislature is a common but very slippery phrase, which properly understood may signify anything from intention embodied in positive enactment to speculative opinion about what the legislature probably would have meant, although there's been a mission to enact it. In a court of law or equity, what legislature intended to be done or not to be done can only be legitimately ascertained from that which it's chosen to enact, either in express words or by reason and necessary implication. So, Lord, in my respect to the Commission, that's the legal test, and my learned friend gets nowhere near meeting it in this particular case. There are various points he's put forward about Parliament's intention, that the outcomes should be audited and so forth. But the reality is the outcomes of the actual scheme may never have been audited because you can modify the scheme after consultation. That's section 123E6. So if that's happened, then the scheme which has been the assessment won't relate to the actual amended ultimate scheme. I may have taken this a bit too quick, but if your Lordship will look at section 123G, the decision is not whether or not to make the proposed franchising scheme. The decision is whether to make a franchising scheme, and you can modify it from the proposal. So your Lordship would go in here. Authorities bundle. Yeah, it's page 14, I'm grateful. Your Lordship will see the response to the consultation under 123G. It's the authority's decision to whether or not to make a franchising scheme. It doesn't have to be the proposed franchising scheme. And in 123E6 on page 11, they're entitled to modify the proposed scheme after consulting those persons and organisations. That's in the general consultation scheme. So the original assessment, the scheme may change, so the assessment may not actually relate to that. Similarly, in terms of audit, there's nothing in the Act which prohibits a franchising authority from proceeding with consultation if the report under section 123D contains criticism of the assessment which it's done. The authority may not accept those criticisms, and it can say why. So in this case, the court may have seen that the auditors didn't qualify their opinion, but they did write an observations letter where they have various comments to make. TFGM replied to those, they said what they made of them, and that document also went out to consultation. So there's no obligation to consider, to necessarily just stop if there's any criticism.
So, I mean, just to take a very simple example, if you have an assessment which is audited, and the auditors give it a clean certificate, for want of a better expression, you go out to consultation, and some bright bus operator says, actually, we've checked your maths. You've got your maths wrong. Look, in the appendix, you said that the analysis was of sufficient quality. Well, it plainly isn't, because you literally can't add up. Yeah. There is an arithmetic error in the analysis. you say you're not required, as a matter of statute, to go back and reassess and get a re-audit.
Of course. I mean,
You would have, there's no implication, there's no implied term that the auditor's certificate has to be current or unaffected by something in consultation. You say that would be the subject of a rationality challenge if you didn't go back, and if the authority didn't go back and say, oh crikey, well, we'll need to do it again, but it's not actually a statutory requirement.
it's certainly not a statutory requirement. I think one needs to think closely about what might happen in the sequence of events. Let's assume you get a consultation response which says, you've got a big model, it says one of your
Inputs is wrong.
inputs, or the relation between inputs and outputs,
Yeah.
is wrong. Right? And that's what we cite.
Arithmetically wrong,
Well,
demonstrably wrong.
Well, a lot of the, sorry, don't want to get too technical. The things called elasticities in these models about how things, one thing relates to another, and they assume this. And one of the problems about code is it may change those elasticities.
Yeah. But I was postulating a really, really basic error.
Okay.
Okay. Somebody just missed the decimal point out,
Okay.
or something.
Well, if that's right, the first question would be, okay, made a mistake. What's the significance of that mistake? It might be, yes, this bit of maths, but it makes no difference to the ultimate outcome. Yeah. At which point, the authority certainly wouldn't have to do a new assessment. It certainly wouldn't necessarily have to go back to the auditor about it. It would make judgment for about whether it ought to go back to the auditor.
As a matter of statute, you say, it doesn't matter, the authority, as a matter of statute, could shrug its shoulders and say, okay, you pointed it out to us, we don't have to go through the statutory hoops again. Yeah. But obviously, if they decided to shrug their shoulders and do nothing about taking it into account, they would face a rationality challenge.
Well, they'll obviously have to take it into account and work out what its significance was. Whether they would need to go back to the auditor about it would be a matter of judgment for them. I mean, that is going to be very fact sensitive about that. But and indeed, one of the things which could happen, let's assume for a moment you get a perfectly good auditor's report. And then what happens? You have consultation and you get a whole series of criticisms about the auditor. And the authority says, okay, well, we accept those criticisms about the auditor, but we don't think those actually affect what our assessment is about. And we think we can rely on our assessment. And that's a rational judgment for us. In one sense, at that stage, this is why focus on the auditor's audit is slightly strange in terms of the ultimate decision. The ultimate decision is whether the authority is rational in making its decision. And it's much more likely to be influenced in that by whether or not the criticisms of what it's relying on in terms of the actual assessment or whatever else, in this case the COVID impact report, have got merit, rather than whether you found something wrong with the auditor's report. So assume for a moment, my own friend I think has placed a great deal of emphasis on paragraph 1.85 in the guidance. Let's assume for a moment that the auditor had not set them all out, missed one out, and in the normal way in which happy claimants come for judicial review, say, you failed to follow the statutory guidance, the auditor ought to go. And the authority thinks, well, okay, well, maybe they didn't have regard to that, but actually we're quite satisfied. Having seen the criticism of the actual assessment, which has been put forward, it's perfectly reliable, and we want to go ahead on that. Why would that be unlawful? Because eventually the relevant question for the authority is whether or not to make a franchising scheme on the basis of the information it has when it comes to make that decision. The fact that there may be valid criticisms of the auditor's report doesn't necessarily make that irrational, even if the authority accepts those criticisms. It may be justified in proceeding, given what else is happening.
But as a matter of statutory interpretation, you say, given all these possibilities, you just simply can't formulate a line in this to be implied into the statute to determine when you have to go to the auditor to get an audit report of something which isn't an assessment in the first place.
Yeah, exactly.
Okay. So,
anyway.
right.
Can I move on to the rationality ground, which, unless there's anything further I can insist. One of the problems about responding to my own friend's rationality ground is I've had some difficulty in following precisely what the point of rationality is on a number of occasions.
It's morphed a bit, I think, from time to time.
Can I say, the permission's not given on the basis that the authority could not make any decision at all at the relevant time in March. I think it's probably necessary for me to just say something about what the COVID impact report did, in order to understand some of the points being made about the Christians have made. My learned friend Skeleton appears to misunderstand what the COVID impact report actually did. If I could ask you to have his skeleton for a moment. Look at two paragraphs. Firstly, at paragraph 35 of page 13. Where dealing with the assurance review, he says that he didn't undertake any review of the financial models which form part of the assessment. I'll come back there. Instead, it just addressed the approach taken in the COVID report rather than the impact those findings had on the original assessment. And then at paragraph 48, at page 16, and where he says, at the end of paragraph 48, the assurance review instead carried out a much more limited exercise considering simply the approach taken in the quoted report rather than the wider impact on the assessment. Well, in my respect for submission, that portrays a fundamental misunderstanding of what the COVID impact report actually did. The COVID impact report addressed the question whether the key conclusions in the assessment remained valid given the uncertainty associated with COVID. Its findings were about the validity of those conclusions in the assessment in the light of that uncertainty. And that was its purpose. If one looks, just to take the judgment for this purpose, at page 92, at paragraph 59, this is in the judge's report explaining the scenarios. The COVID impact report set out 4 potential scenarios for travel in the light of the pandemic, expressed in terms of pre-COVID typical weekly numbers of COVID bus trips. The report said the purpose of scenarios to enable the key conclusions of the assessment to be tested by reference to such potential outcomes to see whether the uncertainty associated with COVID-19 may make a material difference to these conclusions. That was the point of the exercise. And similarly, at paragraph 162 on page 122, where he says the primary object of the scenarios and the projections of bus use was to enable the key conclusions of the assessment to be tested to see whether the uncertainty made any difference in so forth. So that's what the purpose was, and the judge found it was. So to say it wasn't looking at what the effect, or the whole point of the thing was to see whether it had an effect on the assessment. And can I don't want to take your lordship's in
just out of interest, where did the judge get that from in the
report itself?
In the report itself.
There are a number of places. If you were to go first to page 31 of the supplementary bundle. Paragraphs 1.1.4, 1.1.5, which will see this general purpose on potential impact on what's done. Then 1.15, as my learned friend pointed out, it looks at whether how COVID and scenarios may affect the conclusions in the various cases.
Yes, and the conclusion that, and the conclusion that, and the conclusion that.
So that's what it was testing. And then if one goes forward, for example, so far as scenarios are concerned, if we go to page 40.
Yeah.
I'm going to take this rather quickly, so bear with me.
Sorry, I should.
In 1.4.1, under possible future scenarios, was the last sentence of that. The use of such scenarios enables the key conclusion of the assessment to be tested by reference to such potential outcomes to see whether the uncertainty associated with COVID makes a material difference to those conclusions. That's what their purpose was. And then if one goes ahead, if you go to page 43, you'll see a chart which is the actual scenario showing the projections, which I think is referred to on a number of occasions. and scenario 3, which is I'm afraid we haven't got the coloured version, which doesn't help it. But scenario 3 goes down to 25%, and you can see they've got different matters. And then if your lordship looks...
I think we actually have got the
I have got the coloured one.
Oh, you're doing better than I have. At 1.4.25, as noted above, there have been some developments since projections have developed some of the original assumptions upon which each scenario might develop unsurprisingly prove not prove correct, and some in future will unsurprisingly prove not to be the case. The projections of the scenario are nonetheless useful for the purpose of testing the impact on the appraisal of options. They represent a range of future outcomes that could still come from the interaction of the long-term drivers. And then 1.4.28, not all of these potential scenarios, therefore, are equally likely, but it's helpful that decision makers be aware of a broad range of possible outcomes as to what the market may look like. By covering such a wide range of outcomes that could occur, it's considered the actual outcome would be extremely unlikely to fall outside the range. Decision makers need to be aware that they could be working in a context that looks like one of the scenario one lies between them. None of the scenarios is likely to be exactly what happens to travel, but they help to illustrate the range of potential incomes, whilst future is unlikely to look exactly like one of them. This is a way of making tangible analysis from precision and uncertainty, and also making better judgments. So that's how the scenarios worked. And if I could just show you, for example, by way of what happened with the economic case very quickly. If one goes to page 47, 3.2.8 says, given COVID-19 introduces uncertainty rather than just risk, standard risk assessment techniques develop high and low projections around central case using the existing analytical framework around likely to cover the broad range of possible alternative futures that need to be addressed. Demonstrating resilience of an intervention to uncertainty in economic terms, therefore, is about demonstrating the assumptions are still robust with a reasonably likely set of potential futures. And the way that was done was, if you look at the bullet points, to look at, they used a what-if factoring approach, focusing on the potential downsides. I'll come back to that in a moment, and used the above analysis to consider qualitatively the robustness of the economic case presented, and under what, if any, circumstance the proposed franchising scheme may not have value for money, and how likely this may be. Consider how they could review the commercial levers to adapt the implementation, deal with any downside risks, and reach an overall conclusion about robustness. So that was a general matter. If one's then looking at the what-if testing, which is the sort of numerical part of it, if I put it that way. If you go to page 54, it makes it plain 3.4.3, the analysis presented here does not rebuild the full economic appraisal, and the results are intended only to highlight the uncertainties that exist and to assist in making inferences about the robustness and indeed adaptation. 3.4.4, the what-if test presented here reflects a simple factoring of the appraisal results from the assessment. So the starting point was the actual results in the assessment. Rebasing the appraisal to reflect the change in the size of the bus travel demand by the impact of changes on the aggregate benefits due to the overall change in trip making. So step one was basically, if your usage goes down by 40%, you assume your benefits go down by 40%, roughly, because the rationale for that is the more travel you have, the more benefits you have, and it's fairly straightforward. Then look at the implementation costs. They assume conservatively you wouldn't reduce proportionately, so there's a conservative assumption there. And then looking at some potential downsides tests that consider what level of benefit reduction would be required to mean that the proposed franchising scheme was not value for money. And so different types of things. So some benefits are not dependent on market size, for example, about what type of network you're running, and interoperability, which is about how you use tickets. So what that was done was to see, well, we'll test it. What do you have to lose before you might get to a stage where you lose value for money? And then the outputs of that were considered in a sort of qualitative appraisal for it. So it's basic, it's rather an elaborate way of doing it, but it's basically a sensitivity test on the original assessed benefits. And what you do is you make fairly simple changes to the benefits, costs, and when looking at the financial case, the revenues, and you see, well, what does that tell you? So that's what it did. And the the COVID impact report, as the judge found, didn't update the assessment. It just used the conclusions from it as the starting point. And that's it in the judgment at paragraphs 214 to 216. And the core bundle at page 138. If your lordships will very quickly skim 214 and the first paragraph of the quotation in 216, so that would be sufficient for present purposes. Now, the judge also found that the approach adopted to testing the sensitivity of the conclusions by using the assessment as a credible starting point was not irrational. Your lordship will find that in paragraph 218 of the judgment on the next page, page 139. And your lordship will see there were a number of criticisms as to the what-if report. Use of what-if report summarised the themes. Namely, the assessment does not represent a credible starting point for the analysis. So, if it had been incredible to rely on the outputs, that would obviously have been irrational. He listed them all. He said it's dealt with that particular one. I think the right one. I do not accept it discloses any irrationality of approach. Use a different method of analysis from the assessment, but that didn't make the approach irrational. So, the scheme of the COVID impact report was to use the assessment as a starting point and just do some sensitivity tests, see whether or not, given the range of uncertainty which might be possible, it would still represent value for money or affordability. And I should just say about its conclusions, I think, and then a friend, the judge found that the conclusion, if one looks at page 183 of the judgment, said, page 131, the covert impact report had not concluded the conclusions could no longer be relied on. Now, there's my learned friend read out some of it, but not these paragraphs. Your lordship will see 9.11.4. Sorry, if your lordship wants to go to the covert impact report, I should show you that. This is page 85 of the supplementary bundle. 9.11.4 is dealing with what's called the strategic case, which is the case for change set out in the assessment remains, and the franchising scheme offers greater chance of achieving GMCA's objectives of the bus network and the need for potential partnership options. That's the strategic case. 9.11.5 is the economic case. The analysis in the report confirms on balance the value for money of the proposed franchising scheme is likely to be robust to the uncertainty created by COVID in all reasonably likely scenarios, and also better net benefits. Then 9.11.7, which my other friend did refer your lordship to, actually concludes that it has the level of flexibility required to adapt to changes in demand and reduction in patron mileage, and so maintain its affordability. What the report also addressed was that in a scenario which was thought not reasonably likely, there could be even more difficulties, but there would be, there's then a case actually for intervening anyway. But so far as the likely effects were concerned, those remained likely to be the same in all reasonably likely scenarios. That's what they were doing. Lord, now rationality against that background. But firstly, one has to ask why it would. The authority, no doubt, did get an assurance review, but why would it have been irrational not to have had one? My learned friend has never actually addressed that. We happened to choose one, and I don't think my learned friend criticises us for that. But there's no requirement that you can't rely on your own advisors. Most authorities do rely on their own advisors to advise, and as I say, you're entitled to rely on them, even on my learned friend's case, in replying to criticisms of the assessment during consultation. What was irrational in having regard to the Grant Thornton review. Firstly, what about I think Melanie Francis covered this afternoon the scope of the review, if I can put it that way, and has made a number of points. Firstly, the scope, the instructions of the review were widely drawn and didn't constrain what Grant Thornton could consider or could recommend. Can I just ask your Lordship to go back to the instructions? It's page 143 of the supplementary bundle. And perhaps just explain a little about them. Firstly, about the approach taken. Why, in a sense, was there a question asked about the approach taken? Your Lordship will have seen that Section 123D doesn't mention approach. And there's a reason for that, if I can put it that way. One of the matters in which the Secretary of State gives guidance under Section 123B is about the methods you should use in the assessment. That's in subsection 5 of Section 123B. It's on page 5 of the Authorities Bundle. The Secretary of State may issue guidance in the preparation of the assessment under this section. Guidance may in particular include guidance about the methods to be used when preparing the assessment. So the guidance about methodology, it is something which the Secretary of State provides guidance about. There is some guidance about sensitivity in the guidance, but it's thoroughly unilluminating for present purposes. If one goes to page 16, about the economic case, in paragraph 1.56 of the franchise guidance, this is the second of the underlined sentence. The authorities should also perform a number of sensitivity tests to provide a range of results around the options to account for uncertainty and optimism. Well, it tells you to do some sensitivity tests, but it doesn't tell you how they're to be done. Similarly, on the financial case, in 1.61 on page 17, it's the last bullet point, a sensitivity analysis reflecting the range of financial risks. So, I mean, obviously the assessment did do that, but if it provides no particular guidance about how, or method about how you do a sensitivity analysis or to take account of risk and uncertainty. So one of the things which the authority wanted Grant Thornton to look at was whether the approach which TFJ had adopted, which I've just explained to you, was an appropriate way of going about looking at the uncertainty and testing whether the conclusions remain valid. Secondly, they were asked about the information and analysis of the information, whether it was of sufficient quality. I'm not sure if Justice Snowden thought they hadn't expressed a view about the quality of information. In fact, they did. On page 146 in their conclusions, which one should see in summary what they actually did conclude. They concluded that the approach taken in the COVID impact report in considering the affordability and value for money of the proposed franchising scheme in the light of the proposed impact of COVID-19 is appropriate. And the information and analysis of that information, so it's both of them, contained in the COVID impact report on the affordability and value for money of the proposed franchising scheme is of sufficient quality for the purpose of the report, recognising the uncertainty and difficulty of forecasting out the current environment and therefore the use of the scenarios represents this approach. Now, of course, the purpose of the report, which they're referring to there, is testing the whether the outcomes of the assessment, the key conclusions, remain valid. So they did express it about that. Now, it's true that their responsibilities were not more prescriptively drawn. In other words, they didn't say, do this, do that, beyond that. But one of the other things they were asked to do was to provide any specific recommendations on how the approach, information, and analysis of that information might be improved. And they commented on that as well, under specific recommendation on page 146, that any suggestions and recommendations we've made have been reflected in the final version. So they were satisfied that they couldn't be improved, otherwise they would have reported on it. Now, what Grant Thornton were asked to do is give a professional view, their professional view, on all of those matters, and they were very well qualified to do so. Can I ask your Lordship because they're not simply accountants. If one goes to page 134 in this,
Yeah, although, sorry, can you just pause for a second? I mean, if the auditor is performing a section 123D task, when he's answering the question, is the information and the analysis sufficient, sorry, of sufficient quality? He's addressing of sufficient quality for what? The answer is for the assessment by the authority of the proposed franchising scheme, i.e. whether to do it or not. Whereas the paragraph you've just referred me to at page 146 is doing something slightly different. It's saying the information and analysis is sufficient for the purposes of the report. And of course the report, we know, is testing whether the assessment has materially altered in light of the pandemic. It's not quite the same thing, is it? It's not quite the same thing as saying the information analysis remains of sufficient quality for the purposes of the ultimate decision.
well,
I mean, linguistically, there's a step in between, which is the limited purpose of the report, of the COVID impact report.
of course. But the position would have been, if the auditor thought for a moment, if the auditor thought, well, what you've done to see whether you could still rely on the assessment, given the current uncertainty, is to use this approach. I don't think that's the appropriate way of dealing with it. You should have gone back and effectively looked again at your models or whatever, rather than using their outputs. Yeah? They couldn't have come to the conclusions they did, because effectively that would have been a different approach. One of the things they were recognizing when they said the approach was appropriate was precisely that you've got a situation of uncertainty. You want to know whether you can still rely on the assessment. One of the ways of dealing with that is to look at a range of scenarios and see how does that affect what has come out of the assessment. And if it still remains valid for an affordable strategic case, it's okay in this particular case as well. You can then, you might, if you're an authority, you might think, well, we'll go ahead. We recognise there's greater uncertainty as that. What they're obviously not saying, because they weren't saying that you can be confident that the original. I need to go back to what the assessment included, because what you're bidden to do by the guidance effectively is to come out with a single point estimate, for example, about value for money. It all gets quite complicated about that. So you have a 236.6 million or something benefits. They're not saying that you can rely on that as being the precise benefits you're going to get, but what they are saying is that you can rely on getting the conclusion you're going to get value for money out of the scheme. That's the purpose of the report. Or even if it's not, as the auditor puts to me, it's not exactly the same as what they would have been doing under Section 123D. That's not of itself sufficient from a learned friend's point of view. From a learned friend has to say that it was irrational for the authority to commission a review on this basis, or irrational to say that they could put any weight on what comes out of a review on that basis. So even if it's a more limited review, it doesn't help to say it could have been something else more stringent. If that's what it would have been, he has to show that what was actually asked for and what was got could not rationally be either asked for or relied upon, even to get his case off the ground. And in that respect, one would have to say, why is it that it would be irrational for the authority to ask itself and ask Grant Thornton, are the conclusions still ones we can rely on? And is this an
I thought it was a perfectly rational decision to ask that question.
Yeah. Well,
and then, having asked that question, is it rational to check the way in which that question was answered, or the way in which the authority's executive limb went about answering it was an appropriate approach, whether they adopted a sensible approach. Grant Thornton said yes, they did apply a sensible approach.
And when they come to a conclusion it's the information analysis is sufficient quality for the personal report, that in my estimation is a view they're perfectly able to express. I was just going to say something about who Grant Thornton are for this purpose, because
I think the point maybe that we've got to is that there's a two-stage analysis here. The first is, was the authority rational not to go back and ask for redo the original assessment and audit purpose? It's accepted that their decision is not challenged. In that sense, it's not subject to appeal, it's not challenged. So it's rational for them to adopt a more limited approach, namely asking, has the COVID pandemic changed the assessment, the key conclusions in the assessment? And then the issue is it rational to ask the auditors to check that the information and analysis of the information for that purpose is sufficient?
Yeah. Both the approach and the information and the analysis.
Yeah, and then to rely on the auditor when the auditor, to rely on Grant Thornton.
When it's expressed.
Yeah, but not acting as auditor, but Grant Thornton reporting.
Yeah.
So there are two steps in the rationality test. And you say that it was sufficient for Grant Thornton to say, for the purposes of the CIR that you conducted, the information analysis which you had, the information which you had and the analysis which you conducted was sufficient for that purpose.
Yeah. I'm not entirely sure. It's my minor point. My husband was saying something about information from bus operators and so forth. In fact, there was a lot of information about what had happened in COVID, up to date in the COVID impact report in section 1.2. I think virtually a lot of it came from bus operators, which is there, but I don't want to spend time on that. I think my letter friend also put it a number of other ways. The review should have been both of the assessment and of the COVID impact report. That's one way to put it at one stage. And secondly, whether the original assessment was still reliable. The second point about whether the assessment was still reliable, that was the whole point of the COVID impact report and of the assessment. As for whether it should have been the assessment and the COVID impact report they're asked about, that was in fact a complaint which Herbert Smith's made on behalf of Stagecoach, which was addressed in the consultation report. If you would be good enough to go to page 131. There was a challenge about the scope of work, which was not clear or adequate.
So which one?
Page 131, in the
131.
supplementary bundle. And then if you go to 9.3.14, HSF, that's Herbert Smith Freehills, who were acting for Stagecoach, claimed that there should have been an audit of GMCA's assessment as a whole. In looking only at the COVID impact report, Grant Thornton failed to consider whether the original assessment could still be relied upon and whether there are any omissions in GMCA's approach. HSF themselves state that the conclusions in the original assessment are used as a starting point for the analysis, and GT considered the approach in considering the affordability and value for money of the proposed franchising scheme in the light of potential impact was not appropriate, i.e. not using it as a starting point. It could not have reached the conclusion it did that the approach taken in the COVID impact report was appropriate. Similarly, if GT had considered there had been any material omissions in the approach that made it inappropriate, it was able to say so, and it was able to make specific recommendations on how the approach could be approved within its terms of reference. So if what it wanted to say, well, you should have done a bit more about something, it could have said so, but they thought the approach was appropriate. And in my respectful submission, that's a perfectly acceptable response to that challenge. And certainly that's not been impugned, as far as I'm aware, by Rotala in this claim. So far as whether the assessment was a credible starting point, but that was the whole point of the COVID impact report. The actual point on which the permission was originally granted concerned, insofar as it ever identified a flaw in the learned judge's approach, was his response to the point about the use of the financial models, which is the only place where he said he went wrong. In my respectful submission, he did deal with it. Can I just show you how the matter arose and what the complaints were about the financial models? There were two of them in the amended grounds, which my own friends had. So if you would take the core bundle, firstly at page 206. Paragraph 54 of my own friends' amended grounds. This is about the financial model. There were two which were of relevance, which were D and G, which mentioned the financial models. It says, without updated financial models, it was impossible for Grant Thornton to provide independent assurance on the approach taken by Transport Greater Manchester. And G was the defendants had never addressed the issue raised by BDO in relation to Grant Thornton's failure to review and appraise the financial models used. And it's not entirely clear why in each case, but that was elaborated in their skeleton argument. If I just go on to page 264. That's what they may have meant. Firstly, under D, it refers to the passage in the report that we've not undertaken a review of the financial models which have been updated. The defendant's contention that Grant Thornton were made aware of the models and not been updated and accept this as an appropriate approach in the context of information available appears to conflict with what Grant Thornton said. The above quotation suggests that Grant Thornton appeared to be under the impression when forming and writing their opinion that models had been updated. The result, if what Grant Thornton said is accurate, they believe when the report was written the modules had been updated. And insofar as the consultation view says Grant Thornton knew and subsequently accepted that they knew that the models had not been updated, it does not appear that Grant Thornton used that knowledge. So, in fact, that seemed to be a complaint that Grant Thornton at the time, when they issued their report, thought the models had been updated. And then G, what a friend has referred to, was that because I'll come back to what the clarification they gave it at the top of page 266. Grant Thornton did not exercise any judgment in relation to the scenarios, models, or extrapolations, and the result is defendants could not derive on a rational basis any reassurance. What value does it add? Now, the response to that in our skeleton argument, which I think I ought to show you. Firstly, page 355. This is about little d. We said in paragraph 21, Rotala contends that without updated financial models, it is impossible for Grant Thornton to provide independent assurance on the approach taken. The amended grounds do not state why that is alleged to be the case. They now appear to suggest that when it gave its opinion, Grant Thornton was under the impression that financial models had been updated for the COVID impact report. That's simply wrong. And if I just take your lordship to the references which were given, which are at in the supplementary bundle at page 1. Page 135. The first reference is 9.3.32. Where it highlights BDO suggests that GT understood that financial had been updated when the update of the COVID impact report were not reviewed by them. This is not the case. GT were made aware that no updates had been made to the financial models they were carrying out, and which was also made clear, refers to the section. And 9.3.35, in a note sent by GT to TFGM in December 2020, GT clarified they were aware that the models had not been updated, but wanted the reader to be clear that GT had not undertaken any financial model review beyond what they'd undertaken during the original audit. They clarified the comment in their letter, they're not taking any review, so forth. By stating for the avoidance of doubt, we were not suggesting financial models developed had been updated, rather we had not performed any model audit or assurance on the logic or arithmetic integrity of either the financial model or other spreadsheet analysis developed. And then there's a comment that the actual mathematical analysis doesn't involve any complex modelling, because it's simply some fairly straightforward matters. So they were aware of that. And on the other response to the matter, in our paragraph, sorry, just going back to our skeleton, on page 357.
Sorry, can you just give me the reference to the GT letter
The GT note.
that's referred to 9335? I'm sure I'm aware of it.
In my file, it's just completely collapsed.
It's, supplemental bundle page 135 and 136.
Thank you.
Sorry, I was just being put back together.
135.
I'm being told it's 135 to 136.
No, that's the 9335
Oh,
I've
I'm sorry, I thought
been looking at. Sorry, it's the actual.
The actual note.
Yes.
I don't think the note's in the papers,
Oh, sorry.
if that's what your lordship is asking for. The December 2020 note.
Okay, and what about the comment that? Sorry, sorry, it's my fault. I just hadn't been keeping pace with the cross references. The GT letter is where?
I mean the review letter.
Yes.
The review letter begins at 142 of the supplement.
Right.
You're looking for the comment which was being commented on, if I can put it that way. If you go to 145, I think that might be what your lordship may be thinking about. Under inherent limitations.
Yeah, there we go.
The second was we've not undertaken any review of the financial models which have been updated to produce the COVID impact report. That was what the toing and froing was about. I'm not sure I've satisfied your lordship, but
No, I was actually just wondering whether it was a typo, strangely.
can I just go back to the response to G, I think it was, which is...
Yeah, I was just, sorry.
Sorry.
Okay, well, I'm not completely off field then. It just did occur to me that I just wondered whether it was actually a typo and the word not had been missed out.
Well, not for now.
Was it in their letter?
Yeah. Anyway, but it doesn't matter, really.
Anyway,
That's the way we're
as
going.
I said, there was a note clarifying what they meant.
Yes, that's the point. Yeah.
Well, on the second of the points, which your lordship will call the failure to review and update the issue raised, we did address what the issue raised by BDO was. But I think my learned friend was relying on what he said in his skeleton G, and that was addressed at paragraph 32.
I thought he was more concerned with what was said at F.
F.
In the skeleton. Maybe I've got that wrong, but I thought it was what he said was sort of overlooked by the judge and overlooked generally, was the general point that the level of uncertainty caused by the timing was such the range of financial predictions were too unreliable in view of the timing for it to be said that the 1, 2, 3B criteria could be satisfied.
Sorry. We look into his skeleton argument.
Yes.
Right.
265. I may have got that wrong, but I thought it was F that was going on.
The comment on the timing.
Yes, G.
It's G, is it? I've got it
Yeah.
wrong. Sorry.
No.
Yeah, sorry. I've just checked my notes. That's a red herring. Sorry, Mr. Howell.
No.
Mr. Singh said my point is it didn't address the final point made in 58G.
Yeah.
You just about show us that it did.
Yeah. Well, I think one ought to look at, if you keep one finger in 266,
Yes.
which, and I think he's relying on the 2 paragraphs and possibly what value does it add, I think.
Yes.
Yeah. So firstly, the complaint is they didn't exercise any judgment and about those matters. And the response on that point is at 358, which is the use of the scenario as part of the approach to affordability and value for money in those cases which Grant Thornton said was appropriate. They also expressed its opinion on whether the information analysis of those matters was sufficient quality for the purpose of the report. And it says what it didn't show. So what was actually saying was to say that they hadn't exercised any judgment in relation to the scenarios and so forth was simply incompatible with what they actually had done. Now, I have to say, the point about what value does it add, presumably, what Melanie Frome means is if they hadn't done what he says they didn't do, what value would there be? But if they did do exercise the judgment, well, obviously it has value. So, as I understand it, it's not a freestanding point about value. What the judge made of this, and indeed the other ones, I have to say in fairness to him, the amount of argument about this was exiguous during the hearing, so if any at all. He said in his judgment, at page paragraph 312, he considered the claimant's criticism of this part of the assessment consultation report, and they're addressed separately in detail in Annex 2. And he says, it seems to me they're really just arguments about the merits about which views could differ and do not begin to provide an argument that is rational. Well, in my respect, he's perfectly entitled to come to that conclusion. It's true he doesn't then go on and deal with every single one, but he set out the fact that there are arguments on both sides. And he's perfectly entitled to say, well, that doesn't come near getting near a conclusion about irrationality. I should say, in fairness to the judge, given the number of other points he was dealing with, that he dealt with these matters rather succinctly by comparison with some of the others, is scarcely surprising, particularly in the light of the exiguous nature of any oral argument about them. Well, could I just finally say one thing about the significance of the Grant Thornton review and the ultimate decisions? What the covering report said was reliance could be placed on if one wanted to do that. Of course, by that stage, what actually happened was there had been numerous criticisms of the COVID impact report and its methodology, which were all addressed in extensive detail in the report on consultation. And what the March report generally did was to set out the conclusions of each of those. And what was significant is that both in the reasons given why one should proceed and so forth in the March report and in the Mayor's report, they're all the conclusions reached in the light of the criticisms of the COVID impact report in the consultation report. In many ways, the water had flown under the bridge about the review, because even if the review had been absolutely fine, if there had been something wrong with the COVID impact report or justifiable criticisms of it, that would have been the significant point. And that the Mayor and the authority were, in my submission, perfectly entitled to rely on the advice which was given that the criticism of the COVID impact report were not good, and what the conclusions that could be reached were. And that was a decision they were perfectly entitled to come to. The report didn't say you should rely in response to those criticisms on the audit review by on the assurance review by Grant Thornton. That was dealt with in a separate section, which just simply said you can rely on it if you want. The Grant Thornton review was not used in answer to any of the points of the criticisms, specific criticisms which were made of the COVID impact report. So, in my respectful submission, I haven't taken your lordships to the Mayor's reasons. I hope you will look at them and ask yourself whether, given what my learned friend has said, whether it could possibly have made any difference, because in my respectful submission, I claim it would not. Lord, my lady, unless there's anything further I'd like to assist your lordships with, those would be my submission.
Thank you very much, Mr. Singh.
Yes, my lady, my lords. I noticed the time. I'll be, I hope, very quick. Can I start with rationality? And the last point that my learned friend made, which is a point that he trailed in his skeleton, which was effectively that by the time we get to the Mayor's decision, the assurance review is lost in the mist of time. Therefore, the Mayor effectively didn't express as one of his reasons that he had relied on the assurance review. But we would say, and the documents demonstrate, that the Mayor had read, or said he had read, the reports, and the reports included in them the assurance review. It's at page 445 of the bundle says, I have read the report plus reform consultation and GMC response, and the report on the national bus strategy. And the first one of those is the one that has the assurance review in it. So he doesn't, my learned friend is right to say, he doesn't say he relied on it, but he certainly says he read it. And so any suggestion that it was out of the room completely before the decisions were taken is not correct. I don't think, to be fair to him, I think that's the point that my learned friend was actually making, but in case it's thought that it's somehow suggested that Mr. Burnham didn't look at it at all. The next point that my learned friend made was about 265 of the skeleton and the final paragraph in G. G, the final paragraph of G, at page 266, says, the result is that the defendants could not derive on a rational basis any reassurance from the Grant Thornton report. It's not a complaint about Grant Thornton being irrational. It's a complaint about the defendants being irrational for relying on the Grant Thornton report. And that, we say, is actually not a point which my learned friend's skeleton dealt with below. And we say, and it's not a point which the judge dealt with. Now, the judge dealt with all these points relatively, for my learned friend's phrase, exiguously. But the fact is that that was a point which was made, which was not answered and not addressed. And we continue to make that point in our current skeleton argument, including our skeleton argument for permission to appeal, which was permission was obviously granted on this point, not least because it's tied in with the, as we now know clearly, with the unlawfulness point. But well, I think it's an important distinction, and just to now show you that points that one of the points my learned friend took you to was identical to a point in our original skeleton, our permission to appeal skeleton. At page 72 of the bundle is our original paragraph 73, which refers back to the Grant Thornton explanation that my Lord Justice Snowden was asking about the note and whether that was around or not. I'm sorry, I misunderstood the question, but you can see there that that's what we say at paragraph 73. Not least because we were told that we weren't to improve on that by Lord Justice Popplewell. That is exactly the same point as is made at paragraph 55 in our skeleton for today. So, except in this case, it's got the bundle references, which it didn't have last time. And that is a point that we make, that there were inherent limitations, a lack of review of the financial models. And Grant Thornton's explanation is indeed that they didn't perform any model audit or assurance on the logic of the models or any spreadsheet analysis. And that's a point we make. We say, well, in that case, you can't rationally, as the defendant, rely on what they've done because they haven't updated their analysis. With respect, all of us, whether deliberately or not, during the course of today, have on occasion referred to Grant Thornton in the context of the second report as the auditor. We know that GMCA referred to them as the auditor when reporting on that review. We say that is one of the reasons why we say there was a false sense of security given by their review to GMCA when they decided to recommend that a franchising scheme should be made, and the mayor then accepted that.
Well, where do you even get them relying on it?
Well,
in the light of what Mr. Howells just told us, which is that they go back for consultation, they get responses from consultation which criticise it, they take on board all of that. Where do you get this false sense of security from?
well, they still then rely on it.
But they knew they weren't auditing.
Yes.
This is the whole point. So how could they be confused by the use of their own terminology, auditors, into thinking that there was an audit?
No, I wasn't saying that they were confused by the terminology into thinking that there was an audit. I said that they were deriving a false sense of security from that terminology.
I begin to follow that.
Well, I'm sorry, my lady,
I don't understand how, if somebody uses particular terminology which is inapposite, take that point, it's an inapposite terminology because they're not carrying out an audit, but why the fact that they use that terminology, which they know is not right, gives them a false sense of security?
Well,
because if they know it's not right, how can it give them any false sense?
Well, it's one of the points that we made about the fact that Grant Thornton were re-instructed to carry out a exercise which looked similar on a first read to the audit, but when you actually analyse it, you can see it's very different from the audit, and compounding that by referring to them as the auditor, which they are not, gives a false sense of security. And that's our point. I'm not sure that I can improve it by repeating it, but that is our point. It's a point we make in our skeleton as well, and we made before.
Yes, they may. They may have known they weren't auditors, but if they kept calling them auditors,
Exactly.
maybe they forgot that they knew they
Well,
weren't auditors. Anyway, I'm not sure it's absolutely central to the case.
no, probably not central, my lord, but I'm grateful anyway. But and then it appeared to be suggested that somehow our case on rationality and on what the requirement to have been audited, what has changed somewhat from our skeleton. But in our skeleton, in fact, at paragraph 48 that my learned friend took you to, which is page 16, albeit that is in the unlawful section, but we rely on it on the rationality side as well. The final sentence of paragraph 48 does say that the insurance review carried out a much more limited exercise, simply considering the approach taken in the code report, rather than the wider impact on the assessment. But that is about what we said in our skeleton, and it's what we continue to say now. And we obviously say, in terms of unlawful, that frustrates the intention of the Act. In terms of irrationality, we say no rational decision maker deciding whether to spend public monies on the basis of the information that they have would take a decision on that basis. I don't think there's anything else on rationality. As far as the statutory interpretation point is concerned, without reading it, can I refer you, my lady, my lords, to a case which we added into the bundle about statutory interpretation, which is R on the application of O against these SSHD, which is at pages 91 and following, Supreme Court decision. And you will have seen, or you will see within that we point out the approach which is clear as to statutory interpretation, which appears in the decision between paragraphs 28 and 32, where the black lines are. So for your note, that's 99 to 100 of the authorities bundle, and I don't disagree with, obviously, with any of the authorities that my learned friend has put forward on his basis. We simply say that what the exercise on the unlawful question is, of course, an exercise of statutory interpretation as a first step, and we obviously say that you will take the same approach that the Supreme Court says to take in their very recent decision on the matter.
Does it add anything to?
Well, it doesn't refer to, in the same way as it doesn't refer at all to INCO. INCO is a very different case. On its facts, as you probably know, what happened in INCO was that there was a decision by the first instance judge not to give a stay to arbitration. And the Court of Appeal said that was wrong, but had to consider whether they actually had jurisdiction to hear the appeal in the first place, because in the previous Act they did have jurisdiction to do that. As you know, the Arbitration Act provides for a number of things that the Court of Appeal doesn't have jurisdiction to do, but one of them wasn't that.
Yes.
The new Act appeared by a side wind to have taken away the Court of Appeal's jurisdiction. The Court of Appeal said, well, they didn't mean it. And the House of Lords and Lord Rickle said, no, they didn't mean it, because the clear purpose of the Act, the 96 Act, which was, as you, my lady, know, was to consolidate, and this had, by a side wind, by an error. That's a totally different case to the case we are putting. INCO is therefore totally different. But that's why we say you should start, potentially finish, with paragraphs 28 to 32 of our case. Ladies, my lords, unless I can assist you any further.
And I noticed paragraph 31 cites Spath Home.
Yeah.
Different judgment, but still Lord Nichols.
Yes. Thank you.
Well, thank you very much, Mr. Singh. Thank you very much, Mr. Howells. Thank you to all of your industrious teams sitting behind you, solicitors and counsel. You know, a lot of work goes into these appeals. It will hardly surprise you to know that we're going to reserve our judgments. I can't guarantee that you'll get an answer by the end of term, but we'll do our level best.
If it might influence, probably absolutely have no influence at all. Currently, there's a procurement process going on. So obviously it would be desirable, if at all possible, given the other commitments which I'm sure the court has, judgment sooner rather than later.
We'll do our best.
Very